that it can say that each and every provision of the Constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can be neither the assembly can do it,
Yes.
nor the parliament can do
Yes.
it.
Yes.
What you are saying is, while other provisions of the Constitution may be capable of amendment through a process envisaged for amendment,
Yes.
other than, of course, if it is hit by basic structure,
Correct.
this is one provision which can never be amended.
Well, and let it put it differently. But let me put it under what power will this take place? Let's assume they can do it. If my lords put the question to me, under which provision of the Constitution can they do it?
Having a permanency, the whole concept is that Constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically,
Then a political act can be. But there can be a political act.
And those negotiations.
Clause 1 is the answer to this. 370 clause 1, bit by bit, modifications, exceptions, applications have come. Now, and one important thing your lordship may note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can Parliament not have amended the Constitution exercising the 368 power to abrogate 370?
No.
Which means, therefore, that there is a provision of the Constitution, apropos what fell from Brother Justice Kaul, that according to your submission, there is a provision of the Constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note.
So we are creating then a new category apart from basic structure.
No, not
that 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 clause 3 goes and is not brought into service, 370 clause 1 can now be used, continuing with the legislative assembly, with the government of Kashmir, giving its consent, and the entirety of the Constitution can be made applicable to Kashmir still under 370 clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume
Is
what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, it's now, it cannot be.
Not done. 371, according to 370 subclause 1, itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the Constitution applies to the state of Jammu.
Yes.
Then what remains of 370?
Nothing.
Then the only.
To say that you can,
It can
in
be
a sense, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end. The long way around is through 370 clause 1 with applying provision of part
So I'm saying, therefore, said that
Yes.
371, according to you,
Yes.
can mean orders have been issued from time to time.
Yes.
That it can say that each and every provision of the Constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are saying
be.
that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's
he's arguing, but it's certainly not what I'm.
This is what we are saying.
Yes, sir.
That,
Yes.
that may be his
The
interpretation.
expression.
I think, let Mr. Sibal come, because, otherwise that will, I think, Mr. Shankar, what will happen is, we are following a certain line and a link and a syntax, so, I mean, I think, we might be broken up in the nuance of.
Respect Mr. Sibal, he knows the law. We also therefore didn't jump and answer the questions.
I don't think.
See, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes,
Gavai
he
said,
can.
no, this is not what I'm saying, I'm saying something different. So we'll have to see where the call, right?
You
I
can't say
understand.
something
So your
different. There's no
argument I've
issue at all.
understood at your own term. It says that you can keep the shell, but the process is 370 and
So there is another interpretation.
Well, that's, well, that's, the problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
He's
So why
saying there
not?
is a constitutional process by which it can be done under 371.
No, you can't do away with
Okay, I-
370 sub clause 3.
No, suppose, after all, orders have been issued from time to time, bringing different provisions of the constitution in
Right,
force.
right.
Can you not say that another order be issued that it can under one saying that all the provisions of the constitution apply, and list them all of them and say all of them apply?
You know, the problem there is if you say all of them will apply, it applies to what? The concurrent list and the instrument of accession.
Mr. Sibal,
It doesn't apply to the other parts.
insofar as clause D is concerned,
Yes.
there are no limitations. If you read it, much of the provisions of the constitution shall apply in relation to the state subject to such exceptions and modifications as the precedent by order specify.
Correct,
This is governed by second proviso,
correct.
provided further that no such which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that government.
Yes,
The treaty of accession, defense and commerce and
that's
so on.
correct, that's correct.
So if-
And the lists involved there.
And the list involved.
Correct,
So suppose if the parliament
yeah.
decides to make the entire provisions of the constitution applicable to Jammu and Kashmir. Limitation under clause D.
Yes, there is. That's the point I'm making, Malaz. Because the structure of 370 and in the context of the legislature of Jammu and Kashmir is that the residuary power remains with the state.
Because the distinction is that insofar as those powers
Concurrent
under-
list and instrument of accession are two separate things, but there's no issue there. They can do it, both under 371, no issue.
insofar as instrument of succession, those
Only
entities are
only
concerned,
four items.
Their only requirement is consultation.
Consultation. That's correct.
Insofar as the clause D is concerned, the requirement is more stringent and concurrence is required.
That's list 3, mother. That's concurrent list. Residuary power is always with the state. That's the problem. That can't be done by any process. Even under 370 sub-article 1. That's the problem. But I see the point that your Lord is making, my Lord is making, that look, once the Constituent Assembly is over, then of course there's a status quo, it can't be changed. This is what my Lord is putting to me. Yes, there is, but then we have to find a constitutional procedure through which it can be done.
Not amount to equating it with the principle of basic structure itself, that it can never be done. Like you cannot, and that also through a judicial pronouncement,
No,
the
but
philosophy of
Let's
basic structure.
all right, let's not talk of 2023, Madhaj. In 1950, what was the position? This was the position. That it can't be done.
No, but prior to the basic structure doctrine itself, it could be done. Parliament,
no,
how can we say that Parliament could not have exercised its plenary amending power
This is not basic.
to abrogate Article 370?
This is not basic structure, Madhaj. This is a compact between one sovereign and another engrafted in our constitution. It's a constitutional compact.
Then what happened?
Unlike other states where Junagadh, Malaj, he didn't agree, you know, as a political act, you took over Junagadh. He ran away, the Maharaja ran away,
But
Malaj.
that, Mr. Sibal, there, I think we are treading on thin ice, because the moment we say that this was just a recognition, this was a recognition of a compact between one sovereign state and another which forms a part of our constitution, then such a sovereign compact is capable of being overridden
That's all right, Malaj. So then we could.
by the sovereign of the succeeding state.
That debate is a separate debate which doesn't arise in this case because there's a procedure that they have followed. That debate doesn't arise here, Malaj. We're not talking of that at the moment. That's not an issue. We're talking about a procedure in terms of 370, which they followed, consistent with the interpretation of 370. Having taken that position that we need the consent of the Constituent Assembly.
Is
That's-
this the Constituent Assembly according to you?
Yes,
Yes.
that's right. That's the procedure.
That we've
We're
appreciated
only
that
on that.
submission. Yes, of course, we have appreciated that
We are
submission.
limited only on that.
That the
Large-
process, in other words, your contention is that the process which the government of India followed assumes that the proviso to clause 3 applies,
Yeah,
that this change has to be brought in through a constituent assembly.
correct.
But this was evidently not the constituent assembly because A, it was the legislative assembly that you have invoked, and two, even that legislative assembly was dissolved and ultimately parliament was exercising that power under 356.
Now, the larger question, supposing your lordships were to say this is not the right procedure, then the question will arise, can they do it through any other procedure? Then what my lord is putting to me may arise. We're not on that issue. We're not giving solutions to the other side that you can do it under 370. I don't know where that comes from. So that's, there's a limited constitutional issue before you, which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide. If there are other processes available under the Constitution, if they follow them, maybe, whether that may be valid, may not be valid, but I can't answer that question in a vacuum.